The last decade, in particular, has seen a marked increase in violent acts and threats directed toward those in the legal profession. Between 2002 and 2012, the number of inappropriate communications and threats to federal judges more than doubled, from 565 to 1,370, according to statistics from the U.S. Marshals Service. Similarly, a study by the Center for Judicial and Executive Security found that the number of documented shooting, bombing, and arson attacks at state courthouses has increased in every decade from the 1970s, jumping from 29 in the 1970s to 78 between 2000 and 2009. And in just the first 2 years of this decade, 24 such attacks were carried out. About 80% of these incidents are past case related, as people seek revenge against judges and lawyers whom they believe wronged them. At least 40% of lawyers surveyed in 5 of the 6 states reported being threatened or physically assaulted at least once. In most states, general litigators, criminal defense lawyers, family law attorneys, and prosecutors were the most likely to receive threats. While more than half of such threats came from opposing defendants, litigants, the next most likely threat source was the lawyer's own client. Although courthouses remain the most likely place for a threat or attack, a lawyer's place of business, home, and public places such as restaurants are also common sites for potential violence. That phenomenon is likely being driven in part, experts say, by metal detectors and other heightened security measures at courthouse entrances, which prevent violence there, but not at other locations. Reasons and explanations for the increasing attacks are numerous and varied, ranging from easy access to weapons to declining respect for the legal profession and an internet frontier that encourages anonymous written and verbal attacks that can sometimes pave the path to actual violence. The Florida double murderer who scrawled "killer" on his false teeth before being sentenced to death callously taunted the victim's grieving mother at trial, even claiming they had sex at one point. Joseph Zealer, 61, brutally raped and murdered Robin Cornell, 11, and Lisa Story, 32, after sneaking into a Cape Coral condominium in 1990 as the pair slept. Jan Cornell had gone to her boyfriend's house the night of the murders and left Story babysitting her daughter. She returned the next day to find them both dead. When Jan Cornell arrived home about 4 a.m. May 10, 1990, she found Story's and Robin's bodies in adjacent rooms of their shared Cape Coral apartment. He chose the time of day to enter that condominium. He chose to enter stealthily through the back sliding glass door. And then he attacked Lisa Story in her sleep, and he attacked Robin Cornell in her sleep. The state told the panel to think about the pain and suffering both of the victims felt in their last moments. What was 11-year-old Robin thinking? The prosecutor asked. Where's my mommy? Where is Lisa? Why is this man touching me? I can't breathe. The girl and the woman were found in a Cape Coral apartment in May 1990, officials said. Robin's mother had been out for the night and discovered the suffocated bodies when she returned the next morning. Investigators said both victims were sexually assaulted. The case went cold for nearly 3 decades before Zealer was arrested on an unrelated matter in 2016 and had to give a DNA sample, which tied him to the crime scene. The case had languished before authorities got a DNA match in November 2016, linking Zealer to the crime. He was at the Lee County Jail at the time, charged with assaulting his stepson. At trial, Zealer testified his DNA was present because he had sex with Jan Cornell several months before the slayings. Zealer stunned the courtroom when he claimed he had slept with Cornell's mother a few months before the murder. I thought the only way my DNA could have got there was from me sleeping with Jan Cornell, he said. Since the child's mother testified she had never seen Zealer before the homicide, there would be no reason for him to have arranged the photographs on the ironing board or searched the child's backpack for the school photo and left it under the child after she was killed. Prosecutors had presented evidence that photographs' placement indicated premeditation. There was a lot of hair and fingerprints in the house that did not match Zealer, and, if the mother was an average homemaker, then how do we explain their presence? When asked directly about his alleged accomplice via electronic communication, Zealer mentioned blonde hairs recovered from the crime scene, but didn't provide a possible perpetrator. Zealer has brown hair. Zealer alleged someone with very light blonde was involved. In further correspondence, he called witnesses names and accused this publication of being another hack not interested in the truth. When prosecutors noted such material would not have been detectable that long after the alleged encounter, Zealer called the victim's mother a pig who never washed her sheets. After his arrest, Zealer, who beat then suffocated his victim, sent Cornell 3 letters threatening retribution if she did not impede the investigation into the murders. He is still facing a tampering with a witness charge over those letters. Just hours before his sentencing, Zealer was back in court mourning in hopes of getting a retrial and his conviction overturned. But, before the judge could make his ruling in that case, chaos erupted in a Lee County courtroom when Zealer elbowed his attorney in the face. Judge Robert Banning sentenced Joseph Zealer to death for the horrific murder and rape of 11-year-old Robin Cornell and her babysitter 32-year-old Lisa Story in Cape Coral in 1990. Zealer was handed 2 death sentences for each victim. The court concludes that under the laws of the state of Florida, the defendant has forfeited his right to live. 10 out of 12 jurors recommended that Zealer be sentenced to death. The morning of his sentencing, Zealer had a Spencer hearing to provide him with the opportunity to appeal directly to Banning regarding the jury's death recommendation. As the hearing began, Zealer elbowed Shirley in the face. Bailiffs escorted Zealer out of the courtroom. He returned about 10 minutes later with tightened security measures. Hollander recently confirmed that Shirley filed the paperwork indicating he refused to prosecute Zealer after the assault. In his email, Zealer said he also would have elbowed Hollander. If he wasn't so old, and I wasn't so kind, I would have targeted him with the elbow, Zealer said. Hollander said Zealer remains at the Lee County Jail until a separate case closes, charging him with harassing Jan Cornell. A public defender is representing Zealer in that case. Hollander added that Zealer's transfer to Rayford's Florida State Prison, where he'd face execution, is contingent on the active case. The Florida Supreme Court acknowledged receipt of Zealer's death sentence appeal. Paul Fleming, spokesperson for the Florida Supreme Court, said they're unable to confirm whether Zealer is the first convicted felon to appeal his death sentence under a recent statute. There are legal challenges at the Supreme Court regarding the new law, but those concern previous convictions and subsequent resentencing. The new statute opens the door for the death penalty if, at least, 8 jurors vote in favor. Prior, jurors had to vote unanimously in favor. The Florida legislature passed a new capital sentencing law to allow juries to impose a death sentence if at least 8 out of 12 jurors vote in favor. But several death row defendants who were scheduled to be resentenced objected that the new law unfairly made their chances of being sentenced to death more likely. The Florida Supreme Court will now determine whether the old law, requiring a unanimous death sentence, or the new law, requiring only 8 jurors in favor, will apply when they are resentenced. Florida's legal history regarding capital juries is complicated. Up until 2016, The state law allowed for jury recommendations of death if at least 10 out of 12 jurors voted in favor. After Hurst v. Florida, the Florida Supreme Court held that a unanimous jury must recommend death before a judge could consider imposing a death sentence. In 2020, however, in State v. Poole, the Florida Supreme Court, which had recently undergone a change in composition, after several judges reached the mandatory retirement age, repudiated its earlier opinion and issued a new interpretation of the law, stating that while a unanimous jury must find the existence of an aggravating factor in a capital case, which are the factors that make a first-degree murder charge eligible for the death penalty, there was no requirement that the jury's recommendation for death must be unanimous. This opened the door to the current law, which allows an 8-4 split in favor of death. Thank you for watching Death Row.